Right.
Because item number 2 and item number 3.
Yes.
First, let me finish it off, then I will deal with that predicate offence. But this is important for this court. I'll be fast as possible.
Yes, yes.
Fast as possible, because we have no time. I have to go also back today.
Yes.
That's why I'll restrict myself. Because truth is, my learned friend helped me. He has noted what are the points that has been taken by my learned friend for ED and what reply has to be given. First, my lord,
First we'll take up which one?
No, but revision 3.
Yes.
My lord will kindly take up first the PMLA Act. With PMLA Act, kindly take PMLA Act.
PMLA, then CRPC.
PMLA and CRPC and Tersemla. This 3 has to be taken first.
Yes, I mean, the main thing that he has argued the last time, so you'll have to reply to that.
Yes,
is that warrant someone's
No,
that's
why
that's an important issue that has to be settled.
No, that is why I am taking that first point.
Correct.
First point before this court. And please take that Tersemlal.
Tersemlal's case.
Please take in one hand a Tersemlal case also.
Yes. Yes, Tersemlal's case.
Yes. First, I'll give just keep your lordship in hand. First, my answer will be what I said before the court. Is that about in a PMLA case settled by Supreme Court, a summon procedure should be followed. Summon procedure should be followed. Meaning thereby, it is for the purpose of issuing process under 200 to 204, it has to be followed. This is not my interpretation, it is the Supreme Court has laid down in this judgment. I'll take to that. What we said, the issuing of process, a summon procedure has to be followed. Now 204, not in the context of entire trial, my lord, not in context of entire trial. It is in issuance of a process.
Yes.
Now for that, please look into, please take, my lord, the Tersemlal judgment.
Yes, Tersemlal.
Please see para 6 of Tersemlal judgment.
Yes. Yes.
Para 6.
Yes.
While dealing with the complaint under section 44(1)(b, now please have a quick look to 44(1)(b), my lord, in one hand, 44(1)(b) of the PMLA Act. See 44(1)(b). 1B 44.
Yes,
a special court may, upon a complaint made by an authority authorized in this behalf under this act, take cognizance of offence under section 3 without the accused being committed it for the trial. So it is only for the purpose of overcoming 190, my lord, in CRPC. Right, my lord? Now, my lord will kindly now see again paragraph 6 of Tersemlal.
Yes.
The only mode, while dealing with the said issue in paragraph 6, this court held thus. In yes today, your lordship is saying yes today. The only mode by which the cognizance of the offence under section 3, punishable under section 4 PMLA, can be taken by special court is upon a complaint filed by the authority authorized on this behalf. Section 46 PMLA provides that the provision of CRPC, including the provision as to the bails or bond, shall apply to proceeding before a special court and for the purpose of the CRPC provision, the special court shall be deemed to be a court of sessions. However, subsection 1 of section 46 starts with the words save as otherwise provided in this Act, considering the provision of Section 46(1) of PMLA, save as otherwise provided in the PMLA, the provision of the Code of Criminal Procedure Code 1973 for short shall apply to proceeding before a special court. Therefore, once a complaint, now my lord will kindly note down, once a complaint is filed before the special court, the provision of Section 200 to 204 CRPC will apply to the complaint. There is no provision in the PMLA which overrides the provision of Section 200 to Section 204 CRPC. Hence, the special court will have to apply its mind to the question of whether a prima facie case of a commission of offence under Section 3 PMLA is made out in a complaint under Section 44(1)(b) of PMLA. If the special court is of the view that no prima facie case of an offence under Section 3 PMLA is made out, it must exercise the power under Section 203 CRPC to dismiss the complaint. If a prima facie case is made out, special court can take recourse to Section 204 CRPC. Now your lordship will kindly take the CRPC. 190 kindly be seen first. See 190. Also got it?
Yes.
See 190. Yes. Cognizance of offences by magistrate. Subject to the provision of this chapter, any magistrate of the first class and any magistrate of the second class specifically empowered in behalf under subsection 2 may take cognizance of any offence A upon receiving a complaint of facts which constitute such offence. Lordship got it, my lord?
Yes.
Now B, upon a police report of such fact. C, the information received from any person other than a police officer or upon his own knowledge that such offence has been committed. Now when we file a complaint before a trial court, my lord, before a trial court, then what happens in a complaint case? After reading the complaint, if the magistrate finds that complaint has no substance, then it can be dismissed under 203 of the CRPC. Now kindly see 203, what it has spelled out in the judgment. 200 kindly see, my lord, for CRPC 200.
Yes, 200. Yes.
Examination of a complaint. So it will be, the PMLA will be conducted on the basis of the procedure that has been laid down. Now see 200, my lord, examination of a complaint. Now procedure my magistrate not complaint take. 202 is postponement of issuing of process, and 3 kindly be 203, my lord, dismissal of complaint. Yeah. Now, my lord, what happens in normal course when 190 a magistrate take cognizance, my lord, what thereafter it will be done in charge sheet, my lord, in a police case, my lord. Then it is discretion of the magistrate of the court that either a summon can be issued or a warrant can be issued. In a police case, suppose a charge sheet has been laid before the court, because ultimately police has to file a charge sheet before a magistrate. Thereafter, a cognizance has to be taken.
Correct.
Issuance has to be done. So either issuance has to be through a summon or either by a warrant. Either by a warrant. But in a PMLA case, what has been described by Tarsem Lal, a procedure of 200 to 204 has to be followed. So what it says, I will show the judgment of Tarsem Lal. If this is followed, then you don't have the power to issue a bailable warrant or non-bail at the very first instance.
The only thing is that
you should not issue.
Yes, Mr. Raju was submitting.
Yes.
On the point of the punishment part.
Yes.
Punishment part, if it is 7 years, this much.
Now, my lord, I stand corrected. That is not in dispute. I stand corrected. It is not disputed.
Because whether it's a someone's case or warrant kit that has been.
Yes, my lord, that is there.
Has been given in
that is there. But the procedure to be followed is from 200 to 204. Issuing of a process in a complaint case or in a police case, in a police report is being filed. But here the difference is in a summon case, in a complaint case, when the process is issued 204 in both in a police report submitted before a magistrate or in a complaint case which has been filed, then issuing a process under 204. Kindly see now 204, my lord. Yes. See 204 now. See 204.
Yes.
If in the opinion of a magistrate, taking cognizance of an offence, there is sufficient ground for proceeding, and the case appears to be a summon case, he shall issue summons for the attendance of the accused. Now, my lord, your lordship will mark the word attendance. Now, normally, yes. Now it's summon case. Now, kindly see B. Now, kindly see, it is a summon case. This is, he shall issue summons. Right, my lord?
Yeah, he says issue summons for attendance.
Right. Now, see B. A warrant case. He may issue a warrant, or if he thinks fit, a summon for causing the accused to be brought or to appear at a certain time before such magistrate, or if he has no jurisdiction himself, some other magistrate having jurisdiction. Now, your lordship knows the difference. If you are following a case for issuing a process and it is for virtue of 200 to 204, then if it is a summon case, then, my lord, summon will be issued for attendance.
So there is no point of warrant in summons.
Yes. And if now Tarsemlal has been discussed in this case. That's why I am showing this first. Tarsemlal has been discussed. Now, your lordship, this is clear on this point. Now, my lord will kindly see the what para 7 kindly see of Tarsemlal now.
Yes.
See para 7. Because CRPC, my lord, is an old act, because PMLA was drafted later on, my lord.
Yes.
2002 PMLA came into force, but CRPC was earlier. Now, kindly see para 7. If the special court concludes that a prima facie case of commission of an offence under PMLA is made out in the complaint, it can order the issue of process in according with section 2041 CRPC. Section 204 reads as your lordship knows. Now, reading that CRPC. Now, kindly see 8. Para 8, my lord.
Yes.
Now, see 3, my lord. 2, 3, my lord.
Yes, in a proceeding.
In a proceeding instituted upon a complaint made in writing, every summons or warrant issued under subsection 1 shall be accompanied by a copy of such complaint.
Yeah.
Now, what is in our case? My lord, your lordship, just please go back once, my lord, step behind that. 22/3/2024 was the first day when the complaint was filed by the ED and a summon was issued. Cognizance taken, process was issued, my lord, but a copy along with that has to be served.
Yes.
Now, this is what, now my lord, in practice, it is not been served. A copy of the complaint is never been served. What they have done, after issuing of a process, when my lawyer represented on behalf of the accused.
So he didn't receive a copy at that point of time?
And it normally, my lord, it is a voluminous, my lord.
Yes.
14,000, 15,000, my lord.
So
299
yes.
in a pen drive they have served. And to whom they have served? They cannot directly go to the accused. The accused is being represented by a lawyer. It has been served to them. Now you see, further, my lord. Shall be when by any law for now is gone. Now see para 8, my lord. As the punishment for an offence punishable under section 4 PMLA is of imprisonment for more than 3 years, in view of clause 9 of section 2 CRPC, complaint will be treated as a warrant case. Complaint will be treated as a warrant case.
So this is where the problem lies.
No, it's okay, my lord. Let us, that is okay. Let us see that a complaint treated as a warrant case. Under section 204(1)(b), the court can issue a warrant or summon in a warrant case. Therefore, while taking cognizance, the special court has a decision to issue discretion to issue either a summon or warrant.
Correct.
Now, no problem, absolutely. Let us, this is right. Now, kindly see 9, my lord. Now, what my learned friend Indramohan Goswami case is not applicable so where your facts of the case is concerned.
Yes.
Now, see Indramohan. Regarding the discussion under section 2041B, this court has laid down the law in Indramohan Goswami v. State of Uttar Pradesh. This court held that a general rule, unless an accused is charged with an offence of heinous crime and it is feared that he is likely to tamper with or destroy the evidence or evade the process of law, issue of summon is a rule. Is a rule, kindly see, my lord. This court held that in a complaint case, at the first instance, the court should direct serving of summons along with copy of the complaint. If service is avoided by the accused initially, a bailable warrant should be issued. If that is not effective, a non-bailable warrant should be issued in para 55-56 of the said decision read. So this has never happened. My lord, there is no question because law was representing. So
Mr. Raju was basically trying to distinguish this case by submitting that the issue in Inder Mohan Goswami, it was a civil dispute. First time he came, appeared, and immediately warrant was issued.
Yes.
So, but that case and this case is different. That's what he is submitting.
But substance the law, what it says, my lord. No, Inder Mohan Goswami has been followed in Tarsemlal, my lord. Now kindly, it has been followed. Now see para 55 of Inder Mohan Goswami, my lord.
Because Tarsem has discussed this.
Yes, now please see 55, my lord. It has been discussed.
55 paragraph.
Yes, 55, 56, your lordship has seen. Para 9. Para 9, 55 be quoted.
Correct.
55, 56. Quoted, right, my lord? It has been quoted. Now this you please, we already have placed last time, my lord.
Yes.
You see, please see as noted earlier, next page, my lord, as noted earlier, page 179, my lord.
Yes.
As noted earlier, a complaint under section 44(1)B PMLA will be governed by section 200 to 204 CRPC. Hence, the law laid down by this court in the above decision will apply to a complaint under section 44(1)B. Right, my lord?
Yes.
Because
so it is clearly stated that law laid down by this court in the above decision will apply to a complaint under section 44(1)B.
Yes.
So the court has to examine whether it's a complaint under 44(1)B or not.
Because
if it is 44(1)B, then whatever the ratio laid down in this case of Inder Mohan Goswami, that has to be followed. That has been held by Tasemlal.
Yes.
That is a submission,
yes.
right?
This is what. Now para 10 kindly see.
Yes.
While taking cognizance on a complaint under section 44(1)B, if the courts find that filing of the complaint, which is very important, my lord, the accused was not arrested. Let us say in our case, my lord, generally at the first instance, as a rule, the court must issue a summon on the complaint. If the accused was not arrested till filing of the complaint, that's the case, my lord, but has not cooperated with the investigation by defying summon issued under section 50 PMLA, the special court may issue a bailable warrant at the first instance while issuing the process. Now let us say, my lord, this is what the argument was laid down.
Yes.
That section we have filed.
Because many instances when someone's issued
he did not cooperate with the investigation agency.
And that was the basis whereby the learned trial court, special court, has issued the warrant. That is his case.
Now, my lord, this is what his case. But, my lord, initially, when a process was issued, when a complaint was filed, in the complaint, everything was there. The learned trial court.
So, you want to say that at the first time, when the cognizance was taken, all those materials were...
All the materials were there, complaint was filed.
Before them.
We were.
And court was aware that these dates, he did not appear.
Yes. That is why, my lord, despite that, your lordship will order, summon was appeared. Summons was issued, my lord. Despite of that. Now, my lord will kindly see. But even in such a case, it is not mandatory to issue a warrant while issuing process. Instead, issuance of summons would suffice. When an accused is on bail, my lord, this is in process, the special court will have to issue only a summon, so and so. Now, this is not, my lord. Now, So now,
So discretion has been given.
so exception has been carved out so far warrant procedure is concerned, my lord. So it's a discretion, my lord.
It's a discretion.
Yeah, discretion from the very beginning. So, my lord, the CRPC, there is also discretion, and discretion has been exercised. Knowing fully that he has evaded Section 50, he was not cooperating, everything was there.
Now, what are those materials like? I mean, if you can place some materials, when those summons were issued, and whether you have taken any ground why you have not appeared before the investigating authorities.
Yes.
And which are those grounds?
We have communicated by
So,
email
I mean,
also.
where are the materials?
Yes. We'll show, my lord.
I think, if I remember correctly, two emails have been written. Two
Yes.
emails have been written
Yes,
for
yes,
particular
yes,
2
right.
dates.
Yes.
And is there any other material more than
Yeah,
that?
we'll see. No, that is the only material, my lord. I think this is my lord, I think this is regarding about the summon.
No, Colonel, the only thing is that.
My lord,
see,
that is true. Let us say the summon procedure, I make it very clear. I agree to it.
That this is
summon
not,
of
this is,
warrant process-
see, this has been discussed by Tarsim Lal
Yes.
in full details.
Yes.
And after that, prima facie it looks like for this court also that Inder Mohan Goswami's case was discussed.
Yes.
Then stated that
Yes.
that it's not mandatory at the first instance that you should issue warrant.
Yeah.
Preferably maybe a summons should be issued. Then later on maybe a warrant.
which has been, they have followed. They have followed.
They followed.
True or
Now,
they followed?
their case is that in spite of issuing summons, in spite of giving personal appearance, you failed to appear. That is their case, right?
Yes.
So this court wants to see, I mean, while in the investigation stage, what was your conduct?
Yes.
I mean, whether like you have cooperated with the investigation, whether you have not.
But that part, I will just give a reply, quick reply. Now the court, this court cannot look into it that whether that during the investigation what I have done. Because once that particular over, your lordship definitely can, for the purpose, can find it out what has happened. And apparently on the face of it, let us say, because I can't say something which is not there. Investigation, yes. He was summoned, he did not appear. He did not cooperate. But he responded through his email. His wife also was suffering. That was responded to an email. That is there, my lord. It was responded to an email.
No, correct. That's what I mean.
Yes.
I think.
Now
I
see, my
think there
lord,
are 5 or 6 states, right?
But there are some area is very limited so far as these two cases are concerned. What I find that in this case, sir, now this is summons and warrant, your lordship. I think I have clarified it. I accept to it a summon and a warrant procedure also in this case, depending on a punishment. That is true. But the issuing of a process, what they follow is like a complaint under 200 to 204.
So Tarsim Lal has basically interpreted that, like
Yes.
if it is a warrant case also,
Yes.
if the punishment is more than 3 years,
Yes.
up to 7 years, it's a
Yes.
warrant case also, that ideally you'll have to follow
Yes, correct. That's what.
follow what has been discussed in the Tarsim Lal.
Yes, yes.
Correct.
That is there, my lord. So I think now. দেরি হয়ে যাব ভাই, time নাই. We don't have time. What? We don't have time now. My lord, now 2045 kindly see.
2045
CRPC 2045.
Nothing in this section shall be deemed to affect the provisions of section
87. Now you see 87, kindly see 87. See 87, my lord. Order rules regarding process. D.
87B.
87.
Yes, 87.
D, kindly see orders rules regarding process.
Chapter 6 process to compel appearance. This is the chapter. And the other rules regarding processes. We are in the process stage.
My lord, we are in the process test, my lord. Stage. Right, my lord. So am I clear, my lord, on this point?
Yes, no, what is 87 exactly?
87, my lord, see?
Issue of warrant in lieu of or in addition to summons.
Yes. When NBW can be issued, my lord?
So it says,
Sir, this is,
correct, this 87 is
yes,
clear.
yes, 87 is cleared. Now, now, my lord, will kindly see now one provision which my learned pen has have, because now let us say about this part is clear, my lord. I am not saying anything beyond their argument, my lord. Is only restricting. Your lordship has asked, this is what my learned friend has argued. I have given a reply. Now the 2-3 questions which your lordship has asked was very important. Let us see now the dates, which few dates in IA. Your lordship, by the day we remember the dates also in the IA application. First is 2/7/2024. That's an IA 230 of 2024 has been filed. Now in that application, the ED has filed for issuing of an open-ended non-bailable warrant of arrest. Admitted fact, they have not denied, it is an ex parte order that has been passed. If you see the order, read the order of 2/7/2024, it reflected that why an open-ended non-bailable warrant has been issued.
Correct.
On what ground? Because we see that under section 50, lot of summons were issued, even that he evaded. Even there are High Court's order he evaded, having no alternative, the open-ended non-bailable warrant has been issued. To that, my lord, we filed an application, your lordship, remember, IA 531.
That was pending.
That was 531 for recalling / cancellation. Now, it is a fact, one, that is, let me admit that it has not been recalled, but the warrant of arrest which has been issued, that was kept in abeyance. Now the meaning of abeyance is keeping it in under suspension. Now the application which they have filed, now there were 3 directions which has been issued by the learned court. One is that it is be reheard. Number 2, non-bailable warrant of arrest which was issued, that has been kept in abeyance. Number 3 is the next date has been fixed on 18/10/2024, and the personal appearance of the accused has to be there on the next date.
Correct, these are the 4 things.
4 things.
Factual thing. Yes.
Now the fact, now there is a difference of a personal appearance and an appearance. Because my learned friend said, your lordship has categorically asked that on 5/9/2024, why we did not challenge that order. My lord, we will not challenge that order. This order is in our favor. In fact, the ED could have challenged that order. How you are saying the non-bailable warrant should be kept in abeyance? They did not challenge it. Why we will challenge that order? Because your lordship was saying, please show us on 18/10/2024, because if you go back to 13/12/2024, he said there is a violation of order of 5/9/2024. They said violation to the extent that there was an order passed by the court saying that on the next date you have to be personally present. That was that. So when was the next date? Next date was 18/10/2024. My learned friend has not read that 18/10, your lordship repeatedly asking where is that order. I will tell. That order has been read, and I will say that order of 18/10/2024, one, Amit Singh, he appeared and represented the accused number 1. Number 2, ED did not serve the copy of IA of 230 of 2024. Direction was passed, serve the copy to the other side. By the time, in the meantime, the interim order passed earlier will continue. Most important, thereafter, all the accused was not present. It was represented through their counsel. It was dispensed. Personal appearance was dispensed, inclusive of Bhupesh Shah, because Amit Singh appeared.
No, it was there.
So your lordship has seen that. Now the question comes that next day, usual course of business was fixed on 13/12/2024 for appearance. Now your lordship has asked very pertinent. What is, in one hand we say some orders personal appearance, in one order we said that appearance. What is this? Then my learned friend Raju has said, appearance means a personal appearance. If I am not wrong, my lord, your lordship will please correct me. This is what I have heard. On 13/12/2024, or on 18/10/2024, when the normal course of business was fixed on 13/12/2024, he said is appearance. The learned court said 13/12/2024 appearance. My lord, not personal appearance. Now there is a difference between an appearance and a personal appearance.
Is there any material on this?
Yes, please look into the CRPC now. I'll show it what is the material in it. Please look the CRPC now.
Yes.
But
yes.
your lordship, before this, please note it. Your lordship will correct it, they will correct it, except on 5/9/2024, there was an order saying that personal appearance on the next day.
That I have noticed, yes.
Your lordship has said, no other order. Right, my lord? Now please take the CRPC,
It was 5/9, what?
2024.
24.
Yep.
Yes.
Now see the CRPC, quickly, my lord. CRPC.
Yes, service of which provision?
Yes, my lord, if your lordship 204 first, 204.
Yes.
See here 204.
Yes, 204.
Say a summon case, he shall issue a summon for the attendance of the accused.
Correct.
So a summon was issued, my lord. Process, my lord, was issued. Cognizance was taken. So the court has. So the language is attendance. My lord will kindly see.
It's not appearance, it's attendance.
My lord, see, my lord. Attendance is appearance. We don't. The magistrate doesn't write attendance. Your lordship has seen all the orders. It is appearance. So it is a simple appearance. Appearance of what? My lord, appearance doesn't mean that personally one has to appear. Now personal has been shown here.
Yes,
See
when?
205. Now 205.
205, yes.
205. One kindly see. One kindly see. 2051.
Yes.
Wherever a magistrate issues a summon, he may, if he sees reason to do so, dispense with the personal attendance of the accused and permit him to appear by his pleader. Lordship got it, my lord? So, two different language usually used. Once a summon has been issued, attendance. So, my attendance was to the lawyer. Now, when an order is passed, my lord, but normally what we do, in all these cases, we file an application 205 for dispensing. 205.
Mr. The dispensing is different.
No, dispensing is different. See 2052.
See, yes, 2052. Whatever the,
If the magistrate inquiring into or trying the case may, in his discretion, at any stage of the proceeding, direct the personal attendance of the accused. Direct the personal attendance of the accused, and if necessary, enforce such attendance in a manner herein before provided. So personal attendance and attendance are not the same. If you see the 2041 language, it is a summon case. He shall issue a summon for attendance, which has been done.
do you have any ratio or a judicial pronouncement on this? Because see, this has to be read together. As far as I could understand. First is that, okay, someone's case, he shall issue summons for attendance. If the person is not personally there, attending the court, then under 205, then it can be dispensed with. But after dispensation, again,
No.
he can be called for personal appearance.
Yes. Now, what is the order of 5/9/2024? 5/9/2024 order is by the court is the personal appearance.
Yes.
Personal appearance, personal attendance of the accused, not others. Only in that order. So on that day, on the next day, 18/10/2024.
So your submission is basically that there was only one order for personal attendance or personal appearance.
Yes.
But otherwise, all the orders, I mean, there was a simple appearance was directed, or in the simple appearances,
Yes.
because his lawyer appeared, so his personal appearance was not required.
I'll give a simple logic. If fixing 18/10, if the or fixing 13/10 on 18/10 for appearance, that means all the personal attendance of 299 accused has to be in the court. Logically, how it is possible? 299. Well, I have never heard that appearance is a personal appearance. Appearance cannot be a personal appearance. So 299, all 299 accused should have been issued a warrant, all 299. That was not the intention in the normal course of business while doing this, fixing the case. Because your lordship will just remember, 18/10/2024 when the order was passed, the court said we'll defer this. And here, reheard 2/30 of 2024 on 12/12/2024. 12/12/2024, the ED has taken time. ED was not present. That is why my matter was again taken up on 13/12. Because normal course of the case was fixed on 13/12 for appearance. Appearance cannot be only Bhupesh Sharma to all the 299.
No, only thing, this court is taking point of that on that particular date when you were not personally there and your counsel was there, then there was a specific order passed that this is exempt.
Right, but that the court has dispensed, exempted.
And then, like, if he is not exempted, or if he is taking some strong view on that he was not personally appeared, then he shouldn't have written that.
No. Secondly, if you are aggrieved by that, you could have challenged that order. See, my lord, 5/9 next date was fixed on 18/10. 18/10. Now the accused Bhupesh Sharma was not present. Application was filed by the advocate saying that his personal dispense should be. His dispense is exempted. Now the court has exemption not only to Bhupesh, to all the accused. And my lord, if they were really aggrieved by that order, they said there is a violation of that order. Neither they challenge 5/9/2024, neither they challenge 18/10.
That's correct. And what you are saying, that's correct. And like another thing, what this court has noticed is that if you are taking some strong exception of non-appearance, but the order doesn't portray so.
Yes.
It doesn't reveal.
And very interesting, my lord, see 2/8 order of 2024. Kindly see that order in criminal revision 2/8. 2/8. Kindly see of 2/8.
It is there in the compilation, yes?
No, is the compilation also will give lordship. So compilation, sir. No, compilation report. Page 39 of the criminal revision, my lord. Page 39 of criminal revision. I think criminal revision.
Yes, one second.
Criminal revision. Compilation also you will get it, my lord.
Compilation is readily available. So
2/8/2024. Or criminal revision?
2/8.
Yes. Criminal revision, my lord.
The criminal revision 2/8 order is not there in the compilation.
Not there. My lord, your lordship will kindly see at page 39. Criminal revision, my lord.
Yes, one
I'll not take past time, my lord. Criminal revision application.
That is not there, or where it is gone.
It is in the file, I think. No, it's there. You have given that file. No, that file is there.
The file is there, but the two cases are together.
I think in that.
Excuse me?
I think that file will be there.
No, this is 3. This is
Yes.
3, but the file. Where is the
Criminal petition.
criminal petition?
Criminal revision petition.
It mix up করেছে নাকি বেলা কথা কিছু নেই সব
No, this is 3. 2, item 2. Three.
Yes, it is there. I told you to keep this file
Is there?
properly.
Your Lordship got it?
You have put it in here. That day I told you that you keep this file of the petitions properly. This is criminal revision 3. And you have put it in the criminal appeal. I specifically asked you that day that like the files are haphazardly, you have to put it properly.
My Lord,
Yes,
will
yes.
kindly see page 39. Fast, my Lord,
Page
page
39.
39. My Lord, it is after 2/7/2024, my Lord. See, my Lord.
Yes.
When NVIDIA, my Lord, your Lordship, remember date? 2/7/2000, the open and non-bailable warrant was issued. See 2/8/2024, my Lord. By the instant application, the accused applicant Bhupesh Saura is seeking his exemption at page 39.
Yes.
2/8. My instant application, the accused applicant, Lordship got it?
There are two orders, no? The 2/8.
2/8. See at page 39.
Yes, 39. Yes, yes.
IA 506 of 2024.
Yes,
That is my application personal exemption. So by the instant accused applicant Bhupesh Saura is seeking his exemption personal appearance in the court today. Heard so and so. Considering the accused represented by his counsel and the instant matter is a stage of supply of copy and scrutiny of document wherein the presence of the accused is not necessary. The instant may allowed accused applicant Bhupesh is exempted from personal appearance in the court for date. After issuance of non-bailable warrant, my lord. His personal appearance is not required. After issuance of non-bailable warrant of arrest. So on 13/12/2024, my lord, when the matter was taken, the stage was same, my lord. 13/12/2024. So this is what I just clarifying, my lord.
And there was another order also, 29/8/2024.
Yes. And my lord, interesting. See 29/8. My lord, see the order. However, I do hope that no corrosive steps to be taken by the investigating agency.
That's what, like, I mean, there are subsequent two orders,
Yes.
I mean, do not show that
Presence.
the learned trial court had really taken an exception for non-appearance.
Yes.
And if that is the fact, your argument will be, probably your argument that's what you are submitting, that what was the new event that has come to the fore that MBW was reactivated?
Yes.
That is your case?
Yes, correct. That's my case. So 3 is that, my lord. Now, so far as fugitive economic offender is concerned, declaring, that is one.
3 is like we have.
Yes. Because I don't want to say something which is a new one. Again, my learned friend goes, no, something new has been, they argued, so I want to give. I'm just replying to them on their particular.
Yes, 2 replies you have given.
Yes.
Mr. Hussain or Jaheb is there, right?
Yes, Lord. May I only make a very short...
In this petition, I mean, Mr. Raju has argued a couple of things.
Yes, Lord.
Replies were to be given, and like he has replied to those.
Yes. My Lord, as far as the first petition, that is a revision petition is concerned, we have given a written submission.
Yes,
As far as the criminal appeal FEO is concerned, the written submission has been prepared. It is on its way to the court. It will reach in literally less than a minute. We'll hand it over. But I just want to point out, there are 3 very short points. Mr. Raju is connected, but he had requested me to convey to the Honorable Court, my Lord.
Yes.
First is, my lord, my learned friend says, Inder Mohan Goswami means that first you have to issue a summons, then a bailable warrant, then a non-bailable warrant. If you don't follow this procedure, then the NBW deserves to go. Please, Inder Mohan Goswami subsequently gets clarified in Aditya Sarda in an economic offense case. Please only have one sentence of Aditya Sarda, which I will find in volume 1 of my compilation. Only one sentence, if my lord will see. Volume 1 of my compilation. at page 41. This is Aditya Sada, Supreme Court,
Page 41.
page 41, para 28.
But citation, that compilation we should also
Yesterday,
get. No,
Your
when
Worship, yesterday I
compilation.
have submitted from
Please
page
submit.
18 to 24, 42, yes.
But compilation, they should give it to us, or at least the
you
judgment
give
referred.
it
It's
to them
difficult.
also.
No?
Please give it to the other side. Please give it to the other
That's what has happened last time also. We faced a lot of problem.
No, never. 2025 SCC online SC 7.
Yes, Your Worship.
It's an economic offense.
This is in, this compilation is filed in which case?
It is filed in. It's a common compilation, but my lord may use it for the criminal revision. Criminal revision, my lord may use it for.
2008.
Okay. Okay, page 40.
It's the judgment starts at page 18. 2025 SCC online SC 764, page 18.
Yes, this is.
And my lord would see from the very first para that this was an economic offense.
That serious fraud case.
That's right, the serious fraud case.
That
Please,
has been referred to, yes. Yes.
now please turn to my lord page 41, para 28. And my lord was pleased to make a very similar observation that it is a discretion left to the court. Now please see how the Honorable Supreme Court clarifies in the Mohan.
Which para you referred to?
Para 28 at page 41.
Yes, that has been read out.
That's been read out, but only for emphasis I am placing, my lord.
Correct.
Middle of that para, my lord will see as held by 3-judge bench of this court in Inder Mohan Goswami. My lord has that? Somewhere in the middle of the para.
Yes.
The court is empowered to issue even a non-bailable warrant to bring a person to the court when it is reasonable for the court to believe that the person will not voluntarily appear in the court, or the police authorities are unable to find the person to serve him with a summons. This falls squarely within the facts of our case squarely falls. There cannot be a straitjacket formula as sought to be submitted by the learned advocate for the petition respondent that the court must first issue a summons even in a case of a warrant case. That is exactly what, irrespective of...
Your Lordship, this is.
Yes, Mr. Hussain, that I have taken note of.
Yes.
My lord, again,
So this court has to examine the facts, correct?
That's right.
There is not a straitjacket formula. We'll have to apply the principle as per the facts of the case.
my lord,
Now please see, my lord.
no,
Just-
please let me complete. You again. This will never end.
No,
You
Mr. Das, I have
Then I have to. No. See,
I'll
there
only-
is no provision. I am saying, Johab, there is no provision to give another reply.
No,
This
no,
I have not come across.
I just whether he has
No, it's okay.
with the liberty of the court,
Yes,
I'm just
yes,
making
yes. Yes.
three very quick points, my lord.
Yeah, the point.
My
This
lord
is
will-
referred to by him, yes.
This is one. My lord will see in the order issuing NBW, page 61 of the criminal revision petition. My learned friend has annexed that order. The court notices two things, my lord, in the order issuing the NBW. This is an order of 2nd July 2024. And very interestingly, my learned friend has not assailed the correctness of this order. Please mark that. That is very important fact, my lord.
No, that he has admitted it.
That now please see two facts are noted at page 61. I'm not reading it. I'll just summarize it. One is the magnitude of the offense, cheating of gullible investors, and the quantum of the fraud. That is noted that you are telling the large number of people you're investing in Bitcoin mining. My lord, how Bitcoins are generated? Bitcoins are limited number in the entire world. So you have to crack very complex mathematical formulations to create some portion of a Bitcoin and monetize it. So they were cheating gullible investors, saying we are doing Bitcoin mining. If you invest here, we will be able to generate and give you very high return. That's noted in the order.
Yes.
Second, the court notes 6 summonses were issued during investigation. You've not appeared on a single occasion.
No, he is repeating my same.
Now,
why
number,
repeating?
just Dr. Da, I
Repeating
know
again same thing. my
Yes.
lord.
sometimes Dr. Da's repetition is also for emphasis. Now,
It's
second.
like I can say repeat also 10 times. What
Yes,
is the
yes, yes, you
We
complete,
don't
complete.
have time.
Now,
also.
number 3, my lord may consider number 3. Please have Tarsem. Only 2 sentences I want to show, para 25 and 32. My
Yes.
lord, because my learned friend today also.
Please read out.
Please have Tarsem for a moment, my lord. Tarsem, my lord, will find in the same volume 1 compilation. Very same compilation, it is there, my lord. At page 121, my lord will find the judgment.
Yes, which paras? Which paras?
Para 25, my lord, may please come to. The court, the Honorable Supreme Court says
1 second. Para?
25 and 32. For two distinct points, I'm relying on these two paras, my lord.
Yes. Para
Para
25.
25. Now we deal with a contingency where after service of summons issued on a complaint under PMLA, accused does not appear. One category of such cases can be where the accused appears on the returnable date of the summons. My lord may note he has never appeared here. And subsequently does not appear, notwithstanding the furnishing of bonds under section 88. The other category of cases is where after service of summons is made on the complaint, the accused does not appear. This category will also include a case where the accused appears on a returnable date, but on a subsequent date fails to appear. Ours is a fortiori much stronger. In the first contingency where the accused does not appear in breach of the bond furnished under section 88, section 89 confers sufficient powers on the court to take care of the situation. And section 89, my lord, will see when any person who is bound by any bond taken under this court to appear before a court does not appear, the officer presiding in such court may issue. Right, my lord. Then, my lord, may please see para 26. Even if a bond is not furnished under 88 by an accused and the accused remains absent after that, which means summons issued, accused remaining absent despite direction of personal appearance, the court can always issue a warrant under subsection section 70 for procuring the presence of the accused before the court. In both contingencies, when the court issues a warrant, it is only for the securing the accused present before the court. When a warrant is issued in such a contingency, it is not necessary for accused. Now, please see para 32. How in Tarsem Lal, all the accused persons were had in fact cooperated during investigation. Please see para 32, my lord. Coming back to the facts of the case before us, warrants were issued to the appellants as they did not appear before the special court after service of summons. As held earlier, the appellants could have applied for cancellation of warrants issued against them as the warrants were issued only to secure their presence before the special court. Instead of applying for cancellation, appellants applied for anticipatory bail. Now, please mark the next sentence, my lord. It's critical. All of them were not arrested till the filing of the complaint and have cooperated in the investigation. Therefore, we propose to direct that the warrants issued against the appellant shall stand cancelled, subject to the condition of the appellants giving undertaking to the respective special courts to regularly and punctually attend the special court on all dates fixed, unless specifically exempted by exercise of powers.
Yes.
So, this was a case where they cooperated during investigation.
And in this case, he did not appear. That is your
He
case.
did not appear. Lastly, 18-10-2024 order, my lord will note, it says your personal presence is exempted for that very day. This also,
That has been noted. That has been noted.
and mere writing letters, replies to a summons, if my lord accepts that as compliance of a summons, it will create chaos and defeat the whole object of personal presence pursuant to summons. My lords have taken a view in several judgments that if you merely reply to a summons that does not amount to compliance, Bambaji, Noganji versus State of Kutch is one. I will send across that judgment. Those are the only short points of rebuttal. And my FEO written submission has reached the court. We'll hand it over. My lord, Mr. Raju is also here.
My lord, rebuttal I have heard first time. Rebuttal is from my side, not rebuttal from their side. I'll just say these two judges, my lord, the last FAO judgment
This is what
my lord will kindly see SFO judgment is of two judges. Tarsemla judgment is of three judges. They cannot. Indra Mohan is three judges.
Tarsem Lal, he pointed out the behavior of the.
So, my lord, I have argued. I don't want again to open up the case.
No,
Let's
I have
finish
pointed
it off that.
I have taken the point.
Yes.
Whatever.
I don't want to repeat.
He just wanted to emphasize
no, it's okay.
on
I don't want to
things.
repeat this case again.
The same is also two judges. We are in the matter, my lord.
We have taken note. Mr. Raju has also pointed out the other day, and now you have specially emphasized on that.
Very good.
My learned friend is arguing the other matters today, my lords.
Yes,
No,
we
no.
have to finish it.
Which argument?
That matter.
Remaining matters.
Remaining matters
remaining
will be taken on next date.
No, remaining matters, it won't be possible, Mr. Raju, today. Only these two matters. So one matter he has already completed. He has replied to your arguments. Now the other matter, as far as this fugitive is concerned,
Criminal appeal, we are not arguing other matters.
criminal appeal.
It's not possible because I think your lordship will
No,
rise
today
at
it won't be possible.
Today is not.
Other matters, it won't be possible today, Mr. Raju.
Grateful, my lords.
Right.
So this one, I mean,
One only, I'll just give a quick reply in one, my lord. One,
so one issue was Mr.
Yes.
Raju was arguing
Yes.
about compliance of.
my lord, my learned friend, I'll show one averment which has been made. My learned friend, we started with 2F. My learned friend, what I've understood, saying on the date of filing of an application, not necessarily warrant has to be pending. On the date of passing of the order,
Yes.
date of passing of the warrant has to be there. Not only date of filing of the application. Now, if an application is also filed and subsequently it is set aside before passing of the order, then that order goes.
Correct.
Correct? That's what I differ. Only differ with that.
Okay, what
Because
will be-
if you see, section 4, sir.
One second.
Yes, don't give it. Section 4.
So PML section 4, you
4, kindly see section 4, my lord. Sorry, fugitive economic offence, FEO. See section 4.
section 4 of fugitive, yes.
Yes.
Yes. Take it, sir. Yes, sir.
Duly filed. My lord,
So Mr. Raju has emphasized that warrant was not recalled, it was not cancelled, it was there on the date when the order was passed.
And also when the application was made, also on the date the application
No,
was
what
made,
my
it was
learned
only
friend-
in abeyance, it was
but
there.
he was giving an example that even in declaring a fugitive economic offender, not necessarily warrant should be pending. That's what I have heard.
That's not my submission.
Yes, you said on the date when the order is passed.
That was my alternative submission.
Alternative submission. That's what the submission has been made. That's why I'm giving a reply. My reply to the first point is that on 24/10/2024, there was no warrant which was pending because that was kept in abeyance. Kept in abeyance by virtue of 5/9/2024 order. The warrant, non-bailable warrant was kept in abeyance. What the learned trial court, I'll give an answer to that first. What the learned trial court should have done it? Learned trial court should have said, I am not entertaining your application IA 791 of 2024 because on that day the warrant 230 is pending. Let us first decide IA 230 of 2024. What was that, my lord? That was about issuing an open-ended non-bailable warrant of arrest. So, what was the order passed by the court on 5/9/2024? We'll rehear IA 230 of 2024.
That has been noted.
No,
that has
that's
been
what
noted.
I'm saying. It has a connection.
No,
So,
it does have a connection.
it has a connection. Why I'm saying on 24/10/2024, on that particular date, what my learned friend is saying, even it is kept under abeyance, but that non-bailable warrant is still there. Technically, non-bailable warrant is still there, but that non-bailable warrant of arrest has been kept in abeyance by the court for rehearing. So you will rehear, 230 will rehear, then decide whether non-bailable, open-ended non-bailable can be executed or not.
That is noted. That is noted.
So on that date, my lord, that's why alternative argument was made by my learned friend that even it is not required.
No, that I'll ask Mr. Raju for a reply. to
My lord,
that I have noted.
Yes, but I will also give a reply. Now, my lord, please see the fugitive economic offender at section 10.
Yes, section 10. Yes.
Section 10. Please see section 10.
Yes.
See 10(1), where an application under section 4 has been duly filed. Now your lordship has to look into duly filed.
Yes.
The word duly filed. So duly filed is what? With due diligence, with provisions of of the law, 2F has to be complied? You cannot say that 2F will not comply. What is the alternative argument which has been made? Duly filed, there has to be compliance. Compliance,
Meaning
C2F.
thereby the warrant has to be there.
Yes, C2F. No, not only warrant only, C2F.
No, other conditions also. Other
Yes,
conditions also.
not only warrant, other conditions. C1, 2F again, my lord.
Yes. Yes.
My lord, see, a fugitive economic offender means an individual whom, for a moment, let us say warrant of arrest, don't read this first. In relation to a civil offence, has been issued by any court in India who has left India so far, now this word is very important, so far as to avoid criminal prosecution. So, there is no question of me avoiding criminal prosecution when we file a complaint. Process has been issued, I, a lawyer, represented. I did not, it has to be avoid criminal prosecution. And documents supplied to me on a criminal prosecution case, I represent throughout during criminal prosecution case. So what I am saying, if you leave that word, a warrant also, and we say, has lived India for a moment, has left India so as to avoid criminal prosecution, it doesn't say that you have left India only simply. It's left India so as to avoid criminal prosecution. And where is the question of avoiding criminal prosecution, my lord?
So your submission is that when my lawyer is there filing an application, that means that you are not avoiding.
Yes.
Is it so?
With the consent of the court consented, my lord. Approval has been given. Now, see, your lordship was asking 2-3 questions.
Your submission is that this duly filed, I mean, whatever, duly filed is not actually duly filed because
Yes.
the precondition of section 2F was not complied with. That is your submission,
Right.
Okay.
And also, which is when a court deals with an application filed by ED under 4, my learned friend said that no, a lawyer had represented, so it is not required that this mandatory provision has to be followed. This is what your lordship, the argument which has been advanced. My reply, immediate reply, is that when my lawyer appeared, when in a criminal prosecution, one he has appeared. Secondly, when the application was filed under section 4, section 10, the learned court has not followed the procedure, mandatory procedure, a reply has been given by us. Kindly see that. Where we have taken the steps. Reply. See my reply. My reply is at page 123, 136 of the FEO. Kindly see, 136
Page 136.
of criminal appeal.
136, page
136.
136. Okay.
Para 25, kindly we see. Para 135, para 23 first. Para
Yes.
23 first. From the above, kindly see, 135.
Correct.
135, that from the above, it is evident date of the issuance of notice. Under this act, there was no warrant into existence. This is a specific plea has been taken, and the entire proceeding were initiated without the ingredients. So we have mentioned what is 10.3. Now see at 136, my lord. At para 25.
Yes.
That the notice under this act was issued on 24/10/2024 in IA number 791 of 2024, giving a complete go-by to the provision of section 10.3A and section 10.3B of the act. Even if the averment in the application are taken on its face value, accused cannot fall under the definition of fugitive economic offender act. No, this is the point which you have taken, which you have raised before the learned trial court. up to 141.
Yes.
Yes. So my lawyer represented in this case, my lord, throughout, my lord. So there is no question because of 2F will not come into play. Secondly, throughout it was represented. So there is no question, number one, for declaring me as a fugitive economic offender because your lordship has seen 2F1 with the approval of the court. And second, 10 to 10 is a mandatory procedure that has to be followed by the court. Specific, my lord, the stand which we have taken to the trial court. So now,
But what will be your reply on this? I mean, as
No.
far as the complaint is concerned,
yes.
so connected properties, list of people.
No,
persons
no,
were
no,
given.
very
That Mr. Raju has argued.
436.
Yes.
436 crores the figure has been. This 436 is not belonging to only the particular Bhupesh Arora. They are trying to show a huge magnitude of Bhupesh Arora is concerned. My lord will kindly see list of interest. How many accused are there here? 299 accused. Where they have
Yes.
shown, inclusive of me. 179 list of interested person.
No, there was an argument.
No, I know.
There was an argument you have forwarded that section 10,
Yes.
section not section 2, section
10-2.
section 10(2)
Yes.
was not complied with.
Yes.
To your argument, Mr. Raju has argued that since confiscation was not sought for, so that notices are not required to be sent at this point of time.
That can't be. Where is that, my lord? From where he is saying the confiscation was not sought for, where it says, my lord? They 10-2, let us read 10-2, my lord. Let us read 10-2, my lord.
1 second.
10-2. Which is not there in the statute. How can you read it, my lord? Kindly say 10-2, my lord.
Yes.
See, where an application under section 4 has been duly filed, special court shall issue a notice to an individual who is alleged to be fugitive economic offender. 2. The notice referred to in subsection 1 shall also be issued to any other person which has an interest in the property mentioned in the application under subsection 2 of section 4. Shall, my lord, kindly say shall.
Okay.
It is a mandatory, my lord. Cannot say that, and what they are projecting, all these 436 crores, all this Bhupesh Arora, it belongs to Bhupesh Arora. There are 300 accused who appears. They want to prejudice the court by saying, look here, 436 crores. And what is there in the predicate offense? No connection. Your lordship is not dealing with that predicate offense. Your lordship will be strange while looking at the predicate offense. I'll tell in one word. Predicate offense, the figure is saying that there is an SPZ token, my lord, app. From there, what they said, they lured people and they said if you deposit 3,000 rupees, you'll get 6,000, double the amount. They said that in the FIR. And what ultimately happened? A few months. That's
So,
a particular period.
No charge sheet was filed
No,
against
what
you.
is no, my lord, what is there in this case? They cannot connect with this. What they have said in the complaint: 900 crores, 2,300 crores, gaming and betting. What connection it has got gaming and betting, my lord? We don't. Token. If it is a,
disconnected.
if it is, my lord, if it is a, my lord, the criminal activity arising out of the predicate offense is only in respect so far as proceeds of crime is concerned. They can only connect.
Yes, I mean.
They are only investigating proceeds of crime out of a criminal activity. And that figure, your lordship will kindly see, 36,000, 37,000, 10,000. And predicate offense where it is credited to a particular company which is known as Lilian Technocap in a predicate offense. And this Lilian Technocap has not made as a party as an accused in that particular case. And they are dragging all other, my lord, they are going all across India. And they are trying to hold this person and by bringing here and connecting with a predicate offense. See, my lord, today we are 4 years. Now he has not been charge seated in the predicate offense. See, my lord.
That is.
Now I don't want this. I am saying because all the time they are naming Bhupesh Arora, putting a figure of 436 crores. That's why I have to give a reply to this, my lord. So my humble submission before this on to end is that one, my lord, criminal revision. We have made out a case. We have made out a case to the extent that there was a warrant. This court rightly has kept in abeyance that stayed that order because prima facie court was satisfied. Secondly, I cannot be declared as a fugitive economic offender. And secondly, lastly, my lord, my learned friend alternatively has argued a matter. Because forget about that. If an application is also not being filed, while passing of the order, that means 22/1/2025, if a warrant is pending on the date of passing of an order, even then you can be declared as a fugitive economic offender. My lord, I cannot accept that proposition of submission which has been made by my learned friend. That means a judge has to wait till a warrant comes. He will write the judgment, he will sit across and say, no, let a warrant come. We'll see it. That cannot be, my lord. That cannot be, my lord. It's a precondition, my lord. It cannot be, my lord. Then why this definition of 2F? Why this definition of 2F? Otherwise, there was no occasion. No, that is my humble submission before this honorable court. I'll rest, and all the judgment which was filed has no connection with the present case.
So
My lord,
we conclude these two matters,
yes.
Mr. Raju?
My lord, a copy
Yes,
has
the only thing is, the duly word which is used in section 10 is with respect to the form which is there in rules, my lord. Declaration of fugitive economic offenders, forms and manner of filing rules. The rule, whether it is duly, kindly have a look at rule 3, which says how you have to give an index, you have to give a copy of the warrant, you have to give a statement of reasons to believe. That duly complied with in section 10 refers to duly filed refers to rule 3, doesn't refer to 2F or anything else. The form, whether it is in that format, that has to be seen.
Right.
Is there any other query that my lords wants? I can reply, my lord. There is
No, I think you have sufficiently, replied to Mr. Das's argument. And whatever, these things as a clarification has, I think this court has got the clarifications. And these written submissions and written arguments are there, so we'll duly consider a case.
Only one point I believe Mr. Raju wanted to make, my lord, regarding 6 weeks being clearly given even in the order issuing notice under 10.1. So in effect,
yes.
there's compliance with the requirement of 10.3 that you have to give a clear 6 weeks. That was given. That page 38 of the
38 of the order dated 24/10/24.
one of dissent.
Any case that is of no consequence because his lawyer has appeared. That's what I argued.
Yes.
I am giving a note. So far as one is concerned, I have received a note now. I'm just putting across the note which has made so far as criminal appeal 1 is concerned.
Okay.
So they have given to us, we have sent, and we are giving the note. I am giving a note to them, one. So they can hand over to my learned
So
friends.
for the
there.
criminal appeal.
Criminal appeal 1. I have received.
May I take my lord's leave, my lords? May I take my lord's leave?
Yes,
Great,
Mr.
I'm obliged for patient hearing.
three dissent I have.
Lord, we have also given a written submission in this very criminal.
Yes, we have received.
Three I am giving it because they have already given 3. And I have 3 is other side I am handing over 3 also.
Yes.
So all is complete. So far as the notes, exchange of notes, hope so. No notes comes from across anyone.
Yes.
No, we have exhaustively.
Because Mr. Joab, we had an experience. Because in one of the case, 30 we had an experience. All was over. Thereafter we came to the note was given. That's why we said that hope no notes come across.
No, the court had called us to give a note.
No, but we did not
Item
receive any
number,
note. That's why I'm saying.
Item number 2, this criminal appeal number 1 and then criminal revision number 3. These two, you write hearings concluded. You give the names, that name is there. Hearing concluded, judgment reserved in both the cases. Okay? And what about the other one?
That's one predicate offense, your lordship will leave just 2 minutes, predicate offense.
But item number motion 1.
Yes.
Item number
1. Yes, Hukum Chand to go.
So here ED is not a party.
No, ED is not a party. Hukum Chand to go. No. My lord, we took instruction from the client. I have gone to the charge sheet. They are not willing to withdraw it, number one.
Okay.
Because if your lordship looks into charge sheet, my learned friend said you are not named in the charge sheet. There are 4 accused which has been named in the charge sheet. They have added one line if your lordship looks into the charge sheet. Please look into the charge sheet. 1 second. Put the charge sheet.
Yes.
See the charge sheet. So, what is, who are the accused? Kindly see accused number 1.
Yes.
Accused number 1.
Yes, Sankarlal Bana.
No, there's nothing with Bhupeshwara. 2, Punit
One
Kumar.
is Biswa Kumar Jain.
Yeah, those are 4 accused.
No. 1 second. Where the accused number 1 is
Sankarlal Bana.
Sankarlal Bana. Yes.
2 is
Punit Kumar.
3,
Huh.
Jai Bharat Bhai.
And the Vijay
4 is
Sangla.
Vijay. So,
Singla. Huh.
so he is not named.
Yes.
Now, if you see, goes back, last page.
Last page.
See the last page. Accused A1, Mr. Sankala is hereby charged sheeted under section so and so. Further, it is prayed for filing of absconder charge sheet against the other 3 accused, namely so and so. It is praised the Honorable Court for filing of absconder charge sheet against the other 3 accused. Now see, also it is humbly prayed to the learned court under 1738 CRP to please allow IO of the case to submit additional evidence by further investigating the law of other co-accused during the process of trial. So now investigation is pending. Am I right, my lord?
Yes, I mean, like, this is up to you now, whether you want to withdraw
No,
or
we
not.
don't want. My
So you
lord-
don't want, then we'll have to fix it for some other day.
No, that's why I'm saying. My lord, this is a case which my learned friend is harping on. Hukum Chan. I gone through that Hukum Chan. I did not go through Hukum Chan, I have gone. Hukum Chan is 2 page. Kindly see there. I think 2 minutes, my lord. 2 minutes I'll just take. See 2 minutes what is Hukum Chan case.
Excuse me.
See Hukum Chan.
Put in the other cases, this no,
Intimative.
the revision, and for both the cases. You put the cases properly, I'll have to take those files.
They are showing 2 things. One is Hukum Chan
Yes.
and one is paragraph 10. See Hukum Chan, my lord case. 2 minutes my will take, my lord.
Hukum
See,
Chand, yes.
this is an interim order which was placed by Supreme Court. First, kindly see, my lord, it is urged before us the petitioner have no casual connection with DHFL and activities of that company. Petitioner have not been named in the FIR and yet coercive action is taken against them. If the petitioner are not named in the FIR, we fail to understand how the FIR can be quashed at the instant. In any case, if the petitioner are not named in the FIR, the police authority must justify issuance of lookout notice against them and why they are detained in connection with lookout notice on 5/1/2020. Issue notice, liberty served. No coercive action be taken against the petitioner till the next date of hearing in connection with so and so. So what was the case when he projected? A lookout notice was there.
Here
So
it is not there.
some kind of connection was there. That's why Hukum Chand came before this court, came to Supreme Court and said some connection, the lookout notice. Here what is there? They said in paragraph 10 that there is some connection because your lordship knows case diary reveals some connection is there. So what we said, not arguing on merit of the case. Not arguing on the merit of the case because say whenever your name appears in the charge sheet. Now charge sheet has been laid down before the court, find that there are only 4 accused. Further investigation is pending under 173(8). He is showing Hukum Chand saying that you are not named in the charge sheet also, not named in the FIR. So where is the question? You don't have any locus also to come to the court. Now Hukum Chand, interim order, now see the final order what has been by Hukum Chand. Only two
No, that's fine.
yes. See Hukum Chand, man. It is not in dispute that petitioner have not been named as accused in the said crime. If the petitioner have not been named as accused in the said crime, question of quashing of said FIR or the case now under investigation by the Central Bureau of Investigation arising from the said crime does not, as the petitioner will have no locus to seek such a relief. In other words, the petitioners not being named as accused in the said crime or the case now registered by CBI on the basis said crime cannot be permitted to ask question of the proceeding concerning some other person. For the same reason, we do not intend to examine the correctness of the relief claim under section 438 criminal procedure at the instance of petitioner. It will be open to a petitioner to take recourse to pay appropriate remedy as and when they are named by the investigating agency in connection stated offence now under by investigation by CBI. Investigating officer of CBI shall give 48 hours advance notice to petitioner before proceeding against the petitioner so as to enable the petitioner to take recourse appropriate remedy. All contention available both the sides are left open. We have passed this order in the peculiar facts of the present case. We have passed this order in the peculiar facts of the present case and the response filed by respondent in this petition. On the earlier occasion, the court has noticed a lookout notice was issued against the petitioner. It is now clarified. Said lookout notice was issued by local police so and so investigating the crime at that time, which notice has been lapsed with the passage of time. In that sense, the writ petition filed petitioner challenge. So, in that sense, my lord, in that sense, writ petition filed by the petitioner challenge so and so. So, the lookout, the notice lapsed. In that sense, my lord, court said no. Your whole case coming to the court has lookout circular. Now, by effects of time, it has lapsed. In that sense, there is no connection. Where is the question of now? But what is our case?
In this case, what is the connection?
What is the connection? The connection, PMLA, that is why ECIR, I have been dragged by him, because of the predicate offence. Predicate offence, they have been dragged and a complaint has been filed.
That's a separate complaint has been filed.
No, complaint has been filed.
Correct. This was the case initially filed.
Yes.
And while investigating this case, they found out a different case. PMLA has been filed on the basis of the investigation.
No. I'm sorry, my lord. Predicate offence, always when a ECI registered a case, it will be arising out of a predicate case.
Offence.
My lord, directly or indirectly. Directly or indirectly. Now, if you see the order of this court saying that we don't want to go into merit of the case. But what the court said that some type of involvement we have found somewhere in the case diary. This is what in paragraph 10 it has been stated. Para 10, if you see para 10, for a quick moment see para 10 of the
Para 10 of?
Para 10 of the writ, that's the petition, earlier order. See para 10. See para 10. Page 48, my lord.
Yes.
Hukumchand, my lord, Hukumchand first.
Yeah,
he
the
said
CD, now
the
the
CD has called for has been produced and I have perused the same. The investigating conduct so far reveals that a petition is found involved in money transaction which is alternately linked with transaction in the present case. Hence, however, since the petitioner is not pressing for disposal of the case on merit and his limited presence dispose matter with liberty to approach again when the petition named by in connection with the Kohima cyber PS now under investigation, I am the opinion that this petitioner, the instant petitioner, can be disposed of. Now, if your lordship sees the order of this court, kindly see when the order was passed. It was passed on 25/7/2024 at page 44.
Yes.
When the charge sheet was filed, my lord? See the date of charge sheet.
25/6. 25/6/25.
After 15 days.
After filing of our petition, after that 15 days, no? 15 days they have filed. They have completed. They said they have completed. I have not named in the charge sheet.
No. This order was passed on 25/7/2024.
Yes.
And charge sheet was filed.
2025. Here after 15 days. Yes.
Huh?
When we filed this petition after 1 year, because this order was passed on 25/7/2024.
Correct.
So after 1 year, we came to the court by filing on 10/6/2025.
The new one.
New one.
Yes.
10/6/2025.
10/6/2025.
Yes.
And after 15 days, they filed a charge sheet.
Right. Why they filed the charge sheet? 2 minutes I will take while they file the charge sheet. Please see the prayer B, my lord. See the prayer B of the writ petition. See the prayer B. Prayer B and page 15.
Yes.
See prayer E, my lord.
B, yes.
Prayer E. In the alternative, an order directing the respondent to conclude the investigation in Kohima Cyber PS case, quarter petition within a time-bound period as the Solmuka period. So, when they receive this petition, they find an obedience. Why time-bound? Time-bound is not been, my lord, in the CRPC, there is no time-bound. But when the BNSS came into force, if your lordship see
They have
193,
prescribed a time.
BNSS you see, my lord. For a moment, kindly see the BNSS. See BNSS. That is why they have done it, my lord.
No, but the charge sheet, that I'm aware. But
Your lordship is aware that within 90 days,
That is a file.
90 days they have to complete. Earlier there is no time limit which was given. Time limit was not given.
But this charge sheet,
Yes.
charge sheet on the last page that you have read out.
Yes.
Please, let us have a look once
Yes.
again.
My Lord, I have just received instructions, my Lord, that ED will also be impleading itself in this petition, as it has done in many predicate offence quashing cases and permitted all the way up to Supreme Court. In many predicate cases, we have impleaded ourselves. We will be doing that so that we can present whatever we have unearthed in relation to the predicate offence.
So you'll be filing in IA.
So, my lord,
I'll be filing an IA if my learned friend does not object. Even the, even
no.
this,
I will not object it also.
then
So,
this honorable court may implead us, my Lord, without even.
notice has to go. Notice has to go, and my learned friend let him implead as a party in this case. No problem.
Fair enough. Then let,
No problem. Absolutely no problem.
that's very fair of my learned friend. Then
Why not, my lord? My learned.
So see, like, I mean, I am just issuing a notice.
Yes.
This matter, no. I'm not buying your argument. See, this matter needs consideration, and let all the parties come. Then this matter will be, this matter will be considered at length. So this is not a stage. I can summarily dismiss this petition. This is not a case.
my Lord may leave the issue.
There is a predicate offence. After the predicate offence, that PMLA has been filed. So you cannot say that there is no connection at all. There is a connection.
No, but lordship, the matter has
And
already been
another thing,
discussed.
see, another
at
thing
the
is that, no,
at length.
see, wait, another thing is that this is a part charge sheet. The full investigation is not completed.
Yes, but
Then-
but the matter was already heard, and the order says as and when his name was.
May I only say one thing, my Lord?
Only on the basis of that there was a concession sought for, asking for withdrawing of the matter, and this is a criminal matter.
Reality was the matter
this
was
is-
heard at length, lordship.
See, Mr. Counsel, this is a criminal matter, and this is not a simple writ petition. It's a criminal matter. The person has, it's a liberty is concerned. There are a lot of things are concerned. So Article 21 is concerned in this kind of cases, simply on the basis of that there was a line written there that as and when his name will be there, he'll be filing it. That
But
when
lordship,
the
in
matter
what
will
way
not be
his
heard.
fundamental rights are affected in this case?
You are still investigating.
No,
What is your charge?
he's not even last name at the charge sheet says.
It is
the role
also,
of
it is humbly prayed to learned court. So and so, please allow IO to case submit additional evidences by further investigating the role of the co-accused during
Is
the
he a
process of
co-accused
trial.
then, lordship? Is he a
And
co-accused?
one more thing. Further, it is all pray their absconder charge sheet so and so. I mean, this has to be.
No, but
See,
this has to be read with paragraph 10, lordship.
No, see, this has to
No,
be
no.
considered.
This matter has already been discussed,
This
lordship.
matter
This
has to be-
been at length discussed, and the petition was accordingly dismissed with this liberty given, lordship.
May I make one request?
Yes.
The issue of
Why are you opposing so much in issuing notice?
No, because this is already discussed.
The
The fundamental rights of the.
no. See, this court has to see the equity part. Whether you will be prejudiced by that, by any way.
Lordship, the matter is
No,
already
if
discussed.
notice is issued, whether you will
This
be
is Fantax
prejudiced,
official, Lordship.
whether you'll be prejudiced, or whether you will not get an opportunity to argue your case.
No, but
You can still argue
the
the case.
process of the law has to be
You can
maintained,
still
Lordship.
argue your case. When time comes, you can still argue your case that this is not maintainable. You will
I
get the
have,
opportunity.
I have that is precisely the suggestion I wanted to give, that the
Correct.
issue of maintainability can be kept open.
It can be raised. That's what I'm
It
saying.
can be raised.
I will simply issue notice. This court is simply issuing notice, doing nothing else. Only issuing notice, and all the parties can come. This issue. can
Malord,
be
Malord,
argued.
one line may be clarified that the issue of maintainability will also be heard.
Yes,
That
yes.
one line may come, Malord. That
will-
way, both my learned friend and I can examine the issue and
Yes.
come back and.
Lordship,
So,
Mr.
no,
Joel,
only-
you have not appeared. I have given a concession to you. It's only a question of issuing a notice. You come, file an
Liberty-
application, do whatever you want
Liberty,
to do.
liberty to ED
Yes.
to file an application, Malord, may only.
Do it,
Yes, yes,
do
that will.
it. Why
that
there
will
is
be given.
maintainability? You have not entered
This is a
appearance.
criminal matter
Lordship,
involving huge amount of money, involving a lot of people's life. So court will consider this. Only thing is that nobody should be prejudiced and nobody should be unheard. So you will get an opportunity. And why
Lordship,
you are
but
opposing?
when he's not even the case involved, when his rights is like violated, where is his fundamental rights violated in this case?
I'm not getting it. What you're saying?
To come under this under 226, the fundamental rights of the petition has to be violated. Where is it? Besides, it's already decided. So if at all, my Lord feels that it is to be issued, my objection be recorded in view of the already dated.
No, your objection will be definitely recorded. No doubt about that. Your
No,
objection
no,
will
no,
be-
no, in the notice, Lordship.
Yes, in notice I'll say that while issuing the notice, so Mr. So
In view of
Mr.
the-
So and so has vehemently objected. I'll say
In view of the other past in
order passed earlier by the coordinate bench, right?
yes, specifically paragraph 10.
Correct. I'll do
But that issue may be kept open is all I'm requesting, so that
that. See,
Anyway,
this
it'll come
court,
up
this
anyway,
court
so
is
whether it's
this
kept
court
in
is
Giving you
definitely
indulgence doesn't mean that you will say everything now. You come up before the court with an application, then only you can say, you know it, you are experienced in this case. Why you are saying something? If I would have been, I would say, my Lord, this is the position. Come up with an application.
No,
I may object.
Even
please.
if he doesn't
I am
say,
going to-
I'm going to say it. It's
Yes.
okay.
Why? Joel, you know it.
No, let us let us all be clear. The thing is that I have heard this, I have seen this charge sheet also. I have seen this. What is there in the charge sheet? Your objection to issuing notice, I have heard it, and I have heard Mr. Johaib Hussain also that he wants to file an IA for implement. I'll consider that, and I'm of the view that ED also should be given an opportunity, and Mr. Das fairly has submitted that he doesn't have any objection to that. So all the parties will come to the court and issue of maintainability. You can raise it. anytime.
that's fair enough.
That's no point.
That's what. So I'll pass the order accordingly.
Yes,
I'll pass it in the chamber. Then I can cut short it actually.
I have 12:30.
That's
So
all.
I think I'm sorry, my
No,
Lord.
no,
We
no,
have-
no, no.
Because
absolutely
sometimes we
not.
feel.
No, if need be, I can still sit. For another hour.
No, but we feel sometimes I get bit of, because always I'm telling you, don't show too much because time is.
The only thing is that I'll have to reach back. Then I have a training in Bhopal. So that is the thing. I'll have to reach
But
there.
only before your lordship rise, your lordship will please put a date. So for other cases concerned,
Yes,
it
yes.
is
You
not
give
inconvenient.
me a date for this.
To the convenience of my learned friends, since I'm stationed here.
Okay. Mr. Hussain, you need a date. You can agree for a date.
Any date after a few weeks, my lord, we'll put in our implement application, etc. together.
But 11.
Or we'll put a basic, we'll get a copy of the petition, we'll organize the files, my lord.
So you give me a date and so I'll fix it.
My lord, on 10th, your lordship can fix
10th
it.
of November.
That's too soon, my lord. Just 2 weeks at least, if my learned friend can accommodate me.
1 second, November. ED case can be taken up on 10th, my lord. There is no problem.
The other two
10th.
cases.
Yes, two
Other
cases.
two remaining cases.
Yes.
Yes, other two remaining cases, Mr. Hussain will fix it.
No,
Huh?
no.
10.
Item number
Raju sir.
কোনটাই আছে
4 and 5.
কেনেকে কৰিম
4 and
তেতিয়াহ'লে
5
মই
on 10th. 4 and
No,
5
no.
on 10th.
Joab, can it be fixed on 11th, my lord?
11th being a Tuesday would be difficult, then my lord 12th.
12 is
Lordship,
difficult.
in that case, since if not this issue, I may have to file affidavit. I will-
13th?
More time, Lordship.
No, why?
Okay.
No, you're not your case, not your case, I'm saying.
No, he's saying that
It is not your case.
in his case, he's
Dr. Das, 13th or 14th, Dr. Das?
13 is okay, 13.
13.
13 is okay. 13.
so these two remaining cases are on 13th. And what about this case notice? He
Predicate-
needs some more time.
Yeah, he needs time. He needs time. Of course, he needs
So
time.
when
A week thereafter, 19th, a week thereafter, my lord? Only a week thereafter.
19 normal.
December.
That's.
December there are holidays, no? There will be problems. Holiday starts from 13th.
No, I know. December first week.
Or 27th.
27 will be a bit of, because let it be December like first Milo week. That is on.
First is a holidays.
No, first, second.
2nd of December.
2nd of December.
Lord, 2nd again is a Tuesday. Can it be the 3rd or 4th, my lord? Because Tuesdays in Supreme Court has become extremely heavy, my lord.
Fourth, let it be fourth.
4th of December.
Deep privilege. Deep privilege.
I don't know, I don't know. I know, I think, just fourth. Let it be.
So 4th of December. So
Photo ta
দুটা ফাইল এই দুটা
কেতিয়া
চিবি ফাইলকেইটা মোক ভালকৈ দি দিয়ক মই লৈ যাব লাগিব এটা লৈ যাব লাগিব এইটোৰ পৰা এটা থাকিব নটিচ এইটো মই অৰ্ডাৰটা পাছ কৰি দিম ঠিক আছে ঠিক
Second will not be possible. Second, I think.
Second, he's saying it's on Tuesday, so it's difficult for him. He has already left probably.
On first, there's a holiday, or maybe only state.
So let it be on 4th. Let it be on 4th only.
Only state.
Our state holiday.
Yes.
Third one in flexita pass. Fourth. Okay, man.
So 4th only.
Nice.
So I'll pass this order after.
Yes. Deeply obvious.
First, one case. Those are on the 13th of November. So it's the great Mr. Alala. What are we first? Done. Finally, at least. What are we first? No. Not only him. Not only him. You know,